West 4, all clear.
All right, Janet, take a break.
Okay.
Marty! There's been an explosion!
There's a fire! There's a big fire!
The people are running out of the plant. My eyes are burning.
You better send someone. The people, they're falling down. Marty, I think it's poison.
I think it's...
Yeah, this is Mark Jessup. There's a problem at the Mayfield plant. We got fire, some sort of toxic smoke. What should I do? Contact disaster response, the state people?
Sure. Then call Morgan Seiler.
I'm sorry, but aren't those...
Yes, there are lawyers. Call them.
Hello, Mr. Morgan.
Morgan Seiler. 今日はどんなご用でしょうか。
Good morning, Father. Rise and shine.
Good morning, Mr. Morgan.
Thanks for holding, Mr. Costco. He's not back in the office at this time. I can put you through to the voicemail.
You can be honest, you don't really have an apartment, do you? Clearly no one's told you about the firm's locker room or gym.
Last night, a partner I've never met told me to draft these interrogatories for, but not to spend any more than 10 hours on them. I spent 15. So now I have to underreport 5 and pull another all-nighter just to make my monthly billables.
Hillard complaint from Harold Klein.
Great.
Got one for me?
Katya Phillips?
Yes.
On the list.
Thank you. We give up half our lives to get good grades, make law reviews, so we can land a top firm job, and then, as reward, we get to give up the other half.
Edward Hillard called twice, and you promised Jordan Finn 5 minutes.
Thank you. Hello, Harold.
Morning.
Where are we with Hillard?
Complaint was filed late yesterday afternoon in the Western District of Texas. The bad news is it's an unholy mess. The client was storing some unpleasant chemicals and none too carefully. The good news is it's an unholy mess. Hillard needs us. They had a very bad air day in Mayfield. The toxic cloud was ammonia, mostly. There were some pesticides, herbicides, and something called methyl bromide, which is a neurological agent. The insurance carrier screwed around for a while, trying to service the claims. Now it's our turn. Naturally, the plaintiffs are looking to get it certified as a monumental class action.
Any talk of a settlement?
No, they're feeling rather cocky, and with reason. The place looks like Chernobyl.
This may take 3 years to get to trial. There'll be appeals. This is quite an undertaking for our firm.
I'll have litigation associates clear the decks.
What are you thinking about, Mr. Clayton?
Work.
Which case?
Different assignments. The chemical company in Texas, the mass tort.
Bill it. If you're thinking about it, bill it. We can't afford to let the moments slip away. We never get them back.
Yes, sir.
Hillard did that?
No, we did. The client is us. Their interests are our interests.
Seriously, that looks pretty bad.
Yes, it does. And if it didn't, they wouldn't need us.
We're paid handsomely to be objective. Reframe your bleeding heart.
Think of the lawsuit as a train bearing down on Hillard.
The Litigation Express. Okay, so our job is to cut Hillard loose from the tracks. Or are we tied to the tracks too, seeing as how the client is us?
What we are, Mr. Eaton, is a faster, meaner, bigger train headed right at the plaintiffs.
How can we legitimately argue the Hillard plaintiffs haven't been damaged?
Not our strategy, but in a post-Enron world, when it comes to corporations, everybody's got their hands out. Plaintiffs' attorneys are the worst, which is why I want the three of you at the initial meeting. Adam Macy, their lead counsel.
What are we going to do at the meeting?
Absolutely nothing. Just be there. When he sees you, he'll see the settlement money trickling away at $1,000 an hour and realize that Hillard Mayfield will go bankrupt, paying our legal fees before his plaintiffs see a cent. For the time being, I own you. Take no work from any other partners.
The firm agreed to represent a prisoner on Virginia's death row. Wayne Harper is part of the summer intern program.
The summer's over, Jordan.
Virginia Supreme Court follows their own calendar. They just denied review. I know you want to limit unpaid work, but I need an associate to write the federal habeas petition.
It's 10:30. Who is that?
Walker Elliott, Yale, editor of the Law Review, clerked for Justice Arlen.
Supreme Court clerks, huh? They always want to make diamonds, but they don't want to mine the coal.
But clients like the idea of it. Makes them feel like they're getting their money's worth.
Well, let's get ours. Give the Harper case to Mr. Elliott.
He's technically a third year. We can bill him out at $400 an hour.
Then let him handle the esoteric issues. Find a first year to do the grunt work.
I have someone in mind.
The Hillard files en route from Texas. My team will go through them, make a preliminary assessment of privilege and relevance. That sort of thing normally takes a couple of months. Why don't we talk about expert witnesses? We've got all the great ones on speed dial. How goes the search with the second string?
I've got one that slipped under your radar.
Huh.
Nobel laureate, professor of biochemistry, Texas A&M, and she's environmentally friendly. Her initial report describes the properties of the various chemicals and chemical agents being stored at the Mayfield factory, along with an analysis of the burn residue. Dr. Nathanson sent a sample. It's in there. She will testify that not unlike Agent Orange, it could cause birth defects for 3 generations. And it's toxic to the touch.
Whoa, whoa. The hell are you trying to do? Kill us? I mean, can I have kids now?
Chocolate brownie? You're gonna be fine, Ryan. Why don't you sit down? Not the only plaintiff's lawyer that's seen Aaron Brockovich. Come on, Adam. Your clients deserve better than a parlor trick.
You look like you've been skipping the brownies lately, Harold. Have you lost weight? Or just your soul?
You need to set on the bottom to break it up.
All right.
Who's Wayne Harper?
Your pro bono client. It's a death penalty case.
No, client told me not to take on any of the cases.
Don't tell me. According to Jordan Fenn, this baby's yours.
Would you get him on the phone, please?
I've got Mark Clayton for him. He just left for an outside meeting.
Thank you.
Mr. Finn! Mr. Finn!
Mr. Clayton, going for a walk?
No, sir. About the Harper case.
Walker Elliott will take you through all the arcane legal issues and write the habeas petition. You'll do the court appearances, research, interviews.
Actually, I've been assigned to Hillard. Harold Klein told me not to take on any other assignments.
When I interviewed you at Penn, didn't you tell me your strength was multitasking?
With all due respect, sir, I represented the big bad wolf in the Little Red Riding Hood case back in law school, and I lost. Criminal law is not my field of expertise.
You don't have a field of expertise. You're a first year.
Who one day hopes to make partner. Don't you have to bill actual hours for these things? You know, work one, bill one.
Review the file. Talk to Mr. Harper and his former attorney, and if you still want off the case, we'll discuss it. Mark, I think your father would want you to take this case.
Janet, she wasn't my daughter. She was so proud of her job, so proud of the company that she worked for. She took her first paycheck and bought a stock in Hillard. And what did they do? They burned her to death.
I know we're paid to be objective, but...
What about the people who were hurt? Don't worry. Hitler's not getting off scot-free. The families of the dead and injured will get something.
Something?
Like all the workers who were killed, Janet Guzman has an earning stream that can be calculated, paid off, and discounted to present value minus expenses. And we can't think of her in any other way.
She was 20 years old. She's gonna be dead a long time. Never have a wedding or a child or a grandchild. How do you value that?
Well, you can't.
Isn't that what the litigation is about? Negotiating the value of her life?
There are things in life you just can't put a price on.
Is now a bad time to talk about the Harper case?
Ergonomic, ventilated leather, active lumbar support.
What kind of chair do you have?
The one that came with the office. I know they say you can't get a new chair unless the old one breaks. They're surprisingly fragile, especially the arms. You should consider it. You have to think creatively in law. Harper, Mark Clayton, right?
Yeah, look, is now a bad time?
No. Client's got me working on the motion to dismiss the Hillard class action suit. It won't take long.
Well, look, about Harper. I was just about to go over the case files, and I was wondering if there's anything in particular I should be looking for.
Where did you go to law school?
Penn.
Right, got it. So first, figure out what we're trying to achieve.
Well, that should be pretty simple, even for a guy from Penn. We're trying to save this man's life.
Jordan Finn has me supervising a death penalty case. What stage are we at?
He's already been through the state system. We're filing a federal habeas petition.
Then what you need to do is look for errors in the guilt phase or the penalty phase. If there's errors in the guilt phase, he gets a new trial. If there's errors in the penalty phase, the conviction stands, but we can try for a lesser penalty, get him off death row.
What kind of errors?
Constitutional, of course. That's what the habeas is for.
Thank you. I know that, Walker. I understand all of this in theory. I just need to know where to start.
Start with the Virginia Supreme Court opinion. Give it an issue spot. If anything seems an error or strikes you as unfair, note it. It's probably just Virginia state law, but it might be unconstitutional. And then write me a memo. A short one. No more than 2 pages.
Edward Hillard. What's his wife's name? Yes. Are there children? Thank you. Hello, Edward. How are Bernice and the twins?
I didn't fly in from Atlanta for chit-chat, Army. Let's get down to business.
Of course. I've spoken with your in-house counsel and your CFO. Hillard Mayfield has $100 million in casualty insurance. The present liquidated value of Mayfield's assets is somewhere in the neighborhood of $200 million.
And plaintiffs are asking for $1 billion.
Exactly, which is why they've set their sights on you, Hillard International. You're the parent company. You have the deep pockets.
And your big guns in transactional assured me that could never happen.
The plaintiffs can't pierce the corporate veil of your assets unless you're involved in Mayfield's day-to-day operations. Think very carefully of your answer when I ask you this question, Edward. Do you, as CEO of Hillard International, or anyone else at Hillard International, exert supervisory authority over any of Mayfield's Texas operations?
No. No, of course not.
Thank you. You'll be giving interviews. May I suggest you stay out of the sun?
In this appeal, we review the capital murder conviction and sentence of death imposed on Wayne Harper. An Allenton grand jury indicted Harper for the capital murder of Leslie Clark and Michael Clark. DNA tests revealed that the blood found on the rag is consistent with Wayne Harper's DNA profile. The grand jury also returned an indictment for first-degree sexual assault of Leslie Clark. When interviewed by detectives, Wayne Harper made only one statement. I did it.
Mr. Harper, I'm Mark Clayton. I'm your new lawyer with Morgan Seiler. So I have reviewed your case file, and I see that you've confessed.
I lied.
Wayne, why would you plead guilty if you didn't kill the Clarks?
Look, I don't want to die for something I didn't do. It isn't right. You talked to my dad yet?
No, actually, I haven't.
Could you call him for me? Tell him I need to see him. It's important.
Wayne, if you didn't kill the Clarks, do you know who did?
I can't answer that.
You can't or you won't?
It's the same difference. Look, she was a real nice lady. I already admitted that the blood on the rag was mine. I cut myself that day, and I don't know, I must have dropped it at her house.
Excuse me?
This is all in my file.
I drove Mrs. Clark back from the gas station where I worked.
Her car was being serviced, and she was alive when I left her.
Okay, then Wayne, why did you plead guilty?
Mr. Clayton, all these appeals, well, I keep losing them. You may be my only chance.
Harold Klein's been calling. He's at a warehouse in Georgetown with the Hillard Discovery team, and you're already late.
You better put me through to him.
I can't reach him. No reception. If he calls in, what should I say?
Just say that I'm on my way. Is that it?
No. Jordan Finn called.
You need to make an appearance in Virginia Federal Court tomorrow at 9 a.m. Status conference on Harper.
So how do you want me to work tomorrow? Harold Klein wants you in the warehouse bright and early.
What? The courthouse is in Alexandria. Just tell Harold I'll meet him at the warehouse afterwards.
Except you're not going to Alexandria. The appearance is in Norfolk.
Where's Norfolk?
About 3 hours southeast of Harold Klein.
You know what? Forget it. Just put me through to Walker, would you?
Not all documents are created equal. Many are privileged, some are unprivileged, some are relevant, most are irrelevant. The law requires that we hand over documents to the other side that will screw our client, which makes this the ultimate exercise in self-incrimination. So here's the drill. We feed the plaintiffs box upon box of unprivileged and irrelevant dreck.
That would include?
Lunch receipts, emails of the company picnic, company newsletter. Maybe. Understand we have no duty to hand over documents which we claim are privileged, so any documents that are privileged and irrelevant are noted in the privilege log and then withheld, thereby enticing the plaintiff's lawyers to litigate in order to get them.
So basically, the plaintiffs are spending time and money to get something they don't need?
But they don't know that.
And the relevant documents?
That's where this gets interesting. We find a couple that are clearly, absolutely, 100% ironclad privilege, and we toss them into the log. The rest we ship off to a Hillard storage facility in Canada.
They must have skipped over that in law school.
Oh, they most certainly did. But you played the game growing up. The adult version's highly underrated. Hide and seek. Where's Mark Clayton?
Mark, Harold would kill us if he knew we were out getting pizza.
I'll make it up to him, but a man's got to eat. And don't get the pizza. It's all about the cheesesteak.
You know, Clayton, even if you just want a cheesesteak, the firm's dining service will have it delivered.
Sometimes I just like to get out and breathe the fresh air.
Exactly what Morgan doesn't want you doing. He's the second coming of Henry Ford. He's got us on an assembly line. Anytime we're not working, we're not making him money.
My crim law professor used to say that you could find an expert to testify that a Bengal tiger makes a great house pet. So what I can't understand is why Harper didn't have a psychiatric expert testifying at his trial.
Maybe his lawyer screwed up?
Hey, it's the cheesesteak. Extra cheese with peppers and onions, right?
Exactly right. Walker?
I'll have what Mr. Cheesesteak is having.
Thanks.
Future dangerousness.
What?
One of the justifications for imposing the death penalty is that the defendant will pose a threat to people in the future.
Harper's serving a life sentence for sexual assault. He's not getting out. Who's he going to pose a danger to?
His fellow inmates. He might kill someone in prison, someone on death row. Good catch with the psychiatric testimony.
Thanks.
If the state is going to put on psychiatric testimony, they have to give you money for your own expert. I'm pretty sure that Harper was examined by a defense expert, so why didn't his expert testify?
I don't know.
You need to work on future dangerousness.
Wait, I thought you just said I need to...
Future dangerousness is something that Harper's psychiatric expert should have addressed. We're going to say there was ineffective assistance of counsel because his lawyer didn't offer any mitigating testimony when he could have.
Which is the same as having no lawyer at all.
Therefore, a violation of his Sixth Amendment right to counsel.
So what's your deal?
My deal?
Hot girl, hot body. Sorry, it's true. Ink. You must have guys coming out of your ears. Yet you work late every night, weekends. Yeah, I've never seen flowers at your desk. You're never hungover.
I don't really want to talk about me.
Okay, fair enough. Let's talk about me. Well, high school was good. Owned a car. Played varsity lacrosse. So, plus had parents with a fat house and a penchant for leaving town. College was a triumph. You know, lacrosse and a fraternity. But law school, yeah, that was a step down, right? Have you seen anyone now?
Eaton, this isn't some frat party where you grab a beer from the keg and chat me up.
Okay, the answer's no. So is what happened, just a bad relationship? I mean, come on, is it a broken engagement or a messy divorce or what?
No, he asked me so many stupid questions, I bludgeoned him to death.
Okay.
I think I found something relevant.
Is it booking a ticket to Canada?
Wayne Harper versus the Commonwealth of Virginia. You're entering an appearance for Morgan Seiler as the new counsel for Mr. Harper, correct?
Yes, Your Honor. Mark Clayton.
Are you a member of the bar of this court?
I passed the bar last month and have been admitted in the state of Virginia, but not yet to this court, Your Honor.
Morgan Seiler attorneys don't appear in court unprepared.
I'm very sorry, Your Honor.
Mr. Miller,
The court orders you to move the admission of Mr. Clayton to the bar of this court.
Yes, Your Honor. As instructed by the court, I move the admission of Mr. Clayton.
Raise your right hand. Do you solemnly swear as an officer of the court to conduct yourself uprightly and according to the law, and to support and defend the Constitution of the United States?
Yes, I do, Your Honor.
Welcome to the bar of the Eastern District of Virginia. You're here for a status conference.
Yes, Your Honor. We will be filing a habeas petition on behalf of Mr. Harper. We would like to present evidence on future dangerousness.
The state will request immediate dismissal. Any possible claims about future dangerousness are procedurally barred by the petitioner's failure to present them at trial or on appeal in the state court.
You needn't answer if you don't want to. This isn't an argument. But if you choose, you may enlighten the court as to your probable response.
We will argue that counsel was constitutionally ineffective for failing to present expert psychiatric evidence, showing a lack of future dangerousness.
At the risk of repeating myself to the newly sworn-in counsel, any ineffective assistance of counsel claims are barred.
Sit down, Mr. Miller. I will hear argument on the question of procedural bar at 12 o'clock this afternoon.
You did fine. No, really, it's a good sign.
Okay.
You got a few hours before the hearing. Go see Harper's trial attorney. Bring him a bottle of scotch.
I didn't know he drinks scotch.
They all do.
You know, actually, I don't really have time to go and talk to anybody right now. I need to be preparing my arguments.
The best thing you can do is go see this Anson Henry guy. He knows the case better than anyone.
But, Walker, what am I supposed to argue?
You got a pen?
Mr. Clayton. Sounds like a fine southern name. Let's have a drink. Got some clean glasses around here someplace.
Actually, I have to be back in court in less than an hour.
That doesn't necessarily make it a bad idea. You're handling this on your own?
No, we have a team at Morgan Seiler.
I'm sure they pulled together their top guns for Mr. Harper.
Well, he claims he's innocent.
I've been defending criminals since Reagan was president. He was eyewitnessed. There's blood evidence. Police had him dead to rights. I advised my client that if he planned to avoid the needle, he had one option: confess. But I feel sorry for poor Wayne. I believe it was an act of passion. And Mrs. Clark, she was trouble.
At sentencing, you didn't present expert psychiatric testimony.
You're probably thinking that the state has to provide you with money for an expert. But they can provide you with an expert instead. And they gave Wayne, pardon my French, friggin' Dr. Death. Guys testified in 20 capital trials, and in every one he's been 100% certain the defendant would kill again. That's why I didn't put an expert under oath. So here's to that team of yours at Morgan Seiler. You go tell the court all the things I did wrong. Bottoms up.
I found these in Martin Jessup's files.
The Mayfield plant manager.
Correct copies of emails he sent to ToxClean, Mayfield's waste disposal subcontractors, the guys that clean out the inside of the storage tanks. Their contract was up for renewal. They were looking for a hefty increase along with additional safety stipulations. Here's why.
Wrongful death claim.
A couple years ago, some poor bastard died doing the same job. Jessup informed ToxClean that per Edward Hillard, All future contract terms and conditions were to be approved by the main office, and when Hillard International refused to sign off on the new contract, it expired 2 weeks before the explosion.
Because I was watching the bottom line, I'm screwed.
Yes?
And now I'm looking at what?
A punitive damages judgment. Jessup was saving you pennies, and now you may pay as much as $1 billion.
That'll bankrupt my whole company.
It's our job to try and minimize it, Edward. Write down a number. To settle, how high are we authorized to go?
Harold called again. He spoke to Finn, found out your case is a pro bono. Now he wants to speak to you.
Is that it?
No. A fax just came in from the Virginia prosecuting attorney's office.
Read it to me.
Never seen one of these before. Please take note that on this 20th day of September,
That's 3 days ago.
Governor William Teasdale signed a warrant for the execution of Wayne Harper to be carried out by lethal injection on the 25th day of September.
Wayne Harper versus the Commonwealth of Virginia.
Is that a cell phone, Mr. Clayton?
Yes. Your Honor, I've just been informed that the governor has signed a death warrant for my client.
Oh, has he? When's the execution to be carried out?
The day after tomorrow, Your Honor. There is no way we can have Mr. Harper's habeas petition finished in time.
I agree with you, counsel. I take it you are requesting that this court issue an order staying the execution.
Counsel has made no such request.
We request a stay, Your Honor.
The state opposes.
Stay is granted. Where were we?
Your Honor, the state moves to dismiss the habeas petition as procedurally barred. Petitioner seeks to use an ineffective assistance of counsel argument to assert claims that Mr. Harper waived by failing to present them during the sentencing hearing or on appeal. Mr. Harper informed the trial court that he was satisfied with his trial counsel. Under Commonwealth versus Anderson, a defendant cannot contradict his prior statement.
Your Honor.
Mr. Clayton, come to the podium.
Your Honor, Anderson is a state court opinion. Ineffectiveness of counsel is a federal constitutional claim. State courts do not instruct federal courts on the meaning of the Constitution.
Virginia law mandates procedures that prisoners must follow in presenting their claims.
But in the majority of cases, trial counsel and appellate counsel are the same lawyer. You cannot expect a lawyer to argue that his own performance is constitutionally deficient, even if he's newly sworn in. As a procedural rule, Anderson is self-defeating, which is why the federal courts haven't enforced it.
Are those Fourth Circuit decisions you're referring to?
Yes, and I have the citations here somewhere, Your Honor, but the question is not whether the defendant was happy with his lawyer. The question is whether or not his lawyer performed within the bounds of professional competence. And if you will look at the trial transcript, you will see that Mr. Harper's actual statement is that Mr. Henry was a good man. Mr. Harper's endorsement had nothing to do with his lawyer's competency. And in any case, Mr. Harper is not qualified to evaluate that competency. Therefore, it is not justified to dismiss our habeas petition without a hearing.
Rebuttal?
Virginia law has upheld Anderson, and state court interpretations of state law are authoritative, Your Honor.
Thank you, counselors. I'm going to rule from the bench. Now, whether Virginia's Anderson rule can operate to bar Mr. Harper's claim is a federal issue. The decisions of the state courts are not authoritative. The state's motion to dismiss is denied. Court is adjourned.
I hope you got a lot of notes on that pad, because we're just getting started.
Hey, what the hell are you doing?
You're Mark Clayton. I saw you in court today. I'm Dick Harper, Wayne's dad.
Mr. Harper, look, I'm really sorry. I meant to call you as soon as I got back to the office, just to discuss your...
Drop Wayne's appeal.
Why?
You ask Wayne what I'm capable of. He'll tell you. You have a safe drive back to D.C. now. Don't go too fast. Might get yourself killed.
Lunch at the Willard. What do you need, Army?
I just wanted to break bread with the new General Counsel of the House Armed Services Committee. The firm misses you.
I heard Harold's got the whole litigation department mobilized. This Hillard thing.
Bill, did you know there's an opening on the Federal District Court of your old hometown, Denver?
No. Hadn't heard that.
Well, how would you like to be the youngest federal judge in history? I'm 6 for 6 in recommending judicial candidates to Senator Lindsay. He's Morgan Seiler, too. A lot of you up there on the Hill. I know what you did for the drug companies. 3 sentences in an appropriation bill pushed through at 2 a.m.
That was a case of national security. Avian flu. The governments need to mass produce a vaccine.
Of course. Hillard is a crucial player in the war on terror. If the plaintiffs are successful, the whole company goes down. 10,000 jobs lost, and Hillard will be forced to default on its contracts with DOD.
Secretary of Defense won't like to hear that.
No, he won't. What we're looking for is blanket protection for the chemical industry. A private act of Congress that would immunize not just Hillard, but all companies doing work for DOD. A shield, if you will, against punitive damages and runaway verdicts. Americans want a strong defense. Make it retroactive to before the accident. Everybody wins.
Except the plaintiffs. It's a big ask.
Then I'll owe you, won't I?
Mark! Lucille Angstrom, good to finally meet you.
You too.
I've made some annotations on these interrogatories. Maybe it's not worth it to go through them one by one. Could you redraft the whole thing with more of an emphasis on assumption of risk? And I know it's kind of a fire drill, but it would be good if you can get these whipped into shape by tomorrow.
Sure thing.
Hope to see you at the dinner later.
What dinner?
It's on your calendar. The Associates' dinner at Armand Morgan's house. Valet parking, address is on the map.
You busy? What? Too dressy?
What time is it?
You got 45 minutes. And how was court?
I survived. Only to have my life threatened by my client's father.
Define threatened. Mark, you need to tell somebody.
I owe $100,000 to Rutgers and another $150,000 to Penn Law. If I die, do you think I still have to pay that back?
No. And you'll actually catch up on some sleep. Seriously, tell somebody, or I will.
Hey, Wonder Kid, you did it. What did I do? Your brief. Judge down in Texas ate it right up. I believe his exact words were, "No siree, Bob, you cannot certify a mass tort."
Excuse me, gentlemen. Harold, we have a surprise visitor.
What the hell are you trying to pull? Huh? A private act of Congress is never gonna happen.
Then why are you interrupting my party?
Because he knows we sucker punched him. We won the motion. He's got no class action. And after the president signs the next appropriations bill, he'll have no punitives.
This is not about me. This is about you. Morgan Seiler can't afford to lose, huh? Lose your client, lose your reputation. I'll take your sneaky little ploy all the way to the Supreme Court.
Well, that'll take at least 7 years. Very long period of gestation during which the widows and orphans you purport to have such compassion for will go uncompensated.
As they say in Texas, you're all hat and no cattle.
Hillard International has 2 no-bid contracts with the Department of Defense, I believe. You're welcome to take off your coat and stay a while, Mr. Macy. There's plenty for everyone.
I'm authorized to resolve this matter here and now. Hillard will ante up $200 million over and above the insurance policy. You're not gonna kick $300 million out of bed, are you?
Stick it in your ear, Harold. My fee is 20% of $1 billion.
So much for widows and orphans. Tell you what, plaintiffs can have the whole pot, $300 million. I'll get Hillard to pay your full percentage. Plus, we'll rebuild the factory. No jobs lost.
I'll have to sleep on that.
No, you won't. This is our written offer. It reflects everything I've just committed to. And don't say I didn't warn you. If I have to go back down to Mayfield, it's balls to the wall. You're familiar with my trial history, Adam. You know the kind of balls I'm talking about. They ain't seen much of in Texas. I'll see you on the next one.
Oh, it's him again.
Mr. Eaton.
Mr. Morgan.
Harold tells me you had quite a scare yesterday.
Oh, the brownie caught me a bit off guard.
You embarrassed yourself, and you embarrassed Morgan Seiler. If it happens again, you're fired. Mr. Clayton? How is the pro bono case?
We were granted a stay of execution.
Yes, I understand Judge Little was very impressed with you. Do you know what pro bono means?
For the good.
Actually, it's pro bono publico, for the good of the public. Do you know who the public is? Well, I can tell you who they're not. They're not you, and they're not me, and they're certainly not our clients. The public is the mob in the street looking to bash each other over the head as often as they can, and lawyers are their favorite weapons. You must come to understand that distinction, Mr. Clayton. In the meantime, enjoy my party. Good night.
Judge Little vacated your order of execution. Now we have a chance to overturn your conviction.
I didn't know I was set to die so soon. Thank you.
You're welcome. But there's more. I met your father, Deke. Wayne, why would your father want me to drop your appeal? Is he involved in these murders? Did he ask you to take the fall for him?
No, my dad didn't do it. But I know who did.